If it pleases the court, my name is Suzanne Howard, and I appear for the defendant, Marshall Ike. Your Honour, my client is a Torres Strait Islander juvenile. He has been charged with 84 counts of breaking and entering and 1 count of stealing. It is my argument that the defendant's admission should be excluded. Several sections of the recorded interview are listed as inaudible, and proper procedures for the interview were not followed. In fact, this is a substantial non-compliance of the Police Powers and Responsibilities Act. It forms the basis of the prosecution's case and is the only piece of evidence they have. In line with Section 130 of the Evidence Act and Section 590AA of the Criminal Code, this court has the power to make a direction or ruling to deciding the admissibility of evidence in a pre-trial hearing. According to Bunning and Cross, the onus is on the defendant to show that there was misconduct whilst obtaining the admission. Your Honour, the police did not comply with their obligations under the Police Powers and Responsibilities Act. The police should have followed certain steps under Section 421 of the Act, which are the relevant principles for questioning amongst children. According to Section 421(2)(a), the police officer must not have questioned the defendant before questioning starts until the defendant was allowed to speak to a support person chosen by them. The defendant did not have a say in who was present with him in the interview. Instead, he was provided with a white, middle-aged woman who was a social worker from an agency with 0 legal services and whose only advice to the defendant was to answer the officer's question truthfully. This support person was not known to the defendant at all. I should also note, Your Honour, that although Section 421 is the applicable provision, Section 420 contains safeguards for people who are Aboriginal and Torres Strait Islander. Therefore, Section 420 implies more motivation to protect and safeguard the defendant as an Indigenous child. In the Police Powers and Responsibilities Regulation, Schedule 9, in the Responsibilities Code, there is Section 23, which outlines the right to communicate with a friend, relative, or lawyer. There is also Section 25, which sets out guidelines for questioning of Aboriginal and Torres Strait Islander people. There is also Section 26, which is cautioning relevant persons about the right to silence. Your Honour, these sections in the police regulation are there for a reason. Gratuitous concurrence happens when an Aboriginal or Torres Strait Islander person agrees with a white person based on a cultural reluctance to displease because of cultural differences, rather than because they actually agree. So, Your Honour, because of this, the standard for an Indigenous juvenile should be high, and the procedures set out in the Responsibilities Code and Police Powers and Responsibility Act were not adhered to. Under Lee, if police question the defendant without giving appropriate cautions, then admissions should not be admitted as they are prejudicial. The defendant was not cautioned properly on the facts. He was not informed of his right to silence or told about the proper procedures to take place in questioning. In the Crown and Swaffield, the High Court excluded evidence as the defendant was not given a right to silence. The probative value of the defendant's admission is outweighed by its prejudicial effect. Admitting such evidence could very likely give more weight than it deserves in a trial because it is the only documentary evidence. Furthermore, the exclusionary discretion or island discretion, which was applied in Bunning and Cross, excludes evidence obtained unlawfully. This is a public policy factor where the extent of the law was disregarded. Admitting such evidence, such as the admission, could deter the dignity of the administration of criminal justice. In the Crown and Day and Annal, the court did not admit evidence due to the reckless disregard to the law committed by the police officers, as they could have easily obtained a search warrant. Your Honour, I humbly request that you exclude the defendant's admission and exercise the Island discretion and the decision in Bunning and Cross. Firstly, the police failed to meet requirements before interviewing the defendant. Secondly, if the admission was admitted, it would render the evidence more cogent. And thirdly, the gravity of the charge is quite serious, and the police could have easily applied the law by following the correct procedures set out in the Police Powers and Responsibilities Act and the Responsibilities Code. The purpose of the breach provisions in the Act is to prevent unfairness amongst juveniles and Indigenous people. Relying solely on an admission obtained improperly does not rationally affect the likely probability that the defendant committed the charges. Other factors are important. For instance, there is no admissible evidence establishing the identity of the offender. Therefore, Your Honour, my defendant experienced unfair treatment as an Indigenous child, and admitting his admission should not prevail, because doing so would discourage officers to uphold the law. Thank you.